Welcome, everybody, to another live stream on the Ray Law International channel. I'm so glad that you could join us today. We have so much to cover today. I'm so excited to have you on board. We're going to wait a minute to let people get connected. I'm going to check with my team to make sure that the sound is good. Okay. Let's see. Go ahead. Anybody out there, if you're connected, let me know that you can hear me and that the sound quality is good. I know we did have some technical issues last time. Hopefully that will be fixed this time. As we talk about the many things about what's been happening simply in the last 30 days. All right, so we got some comments out there and notes, at least on my team, that the sound quality is good. So we're going to get started. I'm your host, Anthony Ray. I will be discussing some of the alternatives that you as an employer HR manager can utilize in your immigration toolkit in order to deal with the challenges that we're getting now and what we expect in the future. So let's jump in. In addition, for our introduction, before we get to the main topic today, as of February 19th, our president, Donald Trump, has signed over 50 executive orders since taking office in January 2025. What the exact number of immigration-related executive orders are is not specified. However, several significant actions have been taken in this area. Notable immigration-related executive orders includes the following four. First, the declaration of a national emergency at the border. This executive order was issued on January 20th. This order aims to enhance border security and address perceived threats from our unsecured border. The next one, the suspension of refugee admissions. This order temporarily halts the admission of refugees into the United States. Now, if you're already in the U.S., you can still file for asylum. But those coming in as refugees, that has been halted. The current administration is trying to make exceptions for certain South Africans, but we're not going to discuss that today. There's so much going on. But if you are from South Africa, you want to check that out because the administration is looking at making an exception to this executive order. The next executive order is called Protecting the Meaning and Value of American Citizenship. Signed on January 20th as well, this executive order seeks to end birthright citizenship for children of unauthorized immigrants and those temporarily in the U.S. The order has been challenged in court and is currently blocked by multiple federal judges. We'll find out how that pans out in about a year and a half or 2 years once it goes up to the Supreme Court. And finally, the next executive order we wanted to highlight today is Protecting the American People Against Invasion. Also signed on January 20th, this order suspends the entry of certain aliens deemed to be part of an invasion through the southern border. So we have several executive orders that are impacting immigration. We expect to see a whole lot more as we move forward. Right now, it seems the administration has split some of its attention to other things in the world, such as global threats and challenges, tariffs, and many, many other things that are going on. So as the lawsuits and the executive orders ramp up, what are the concerns of HR managers? We're going to cover 10 of them as we dive into some solutions for you, which we're going to share shortly. But as we dive in, make sure that you, if you have questions, put it in the chat, please. Don't wait, don't listen. This isn't a seminar. This is time for you to interact with us and have your questions answered. That's what we do the best at, and that's what we would love to hear from you. So if you have questions, put that in the chat. We're also going to put our phone number down there. Feel free to call our office now or anytime to set up an immigration consultation to see how we can solve your immigration challenges as the administration continues to change the immigration landscape. The first of the 10 common concerns of HR managers is increased H-1B scrutiny and restrictions. Strict adjudication, higher denial rates, and the potential for reductions in H-1B visa numbers is a concern that everybody has. To date, we haven't seen that, but these are some things that may come. Number two, TN visa uncertainty. You've already seen our administration attack Panama and other countries. Immigration is just one of those bailiwicks or the tools they use in order to try to get the governments to capitulate to what they would like. The TN visa, what we see is the potential policy shifts affecting Canadian and Mexican professionals under the USMCA. Now, under the TN visa, if you're not familiar, there's a list of professional occupations, and if you fit within those, you can get a TN visa at the border. It's a very good alternative to some of the other non-immigrant visa categories we'll be talking about today. Number three, delays in green card processing. Now, extended processing times for EB1, EB2, and EB3 green cards impacting long-term workforce planning. For some countries, individuals from China, India, or Mexico, the wait times are very long. So, this could increase those processing times. So all the Indian nationals out there and Chinese nationals out there who are sticking it out for 10 to 15 years, with this new administration, we expect that to be a little bit longer. So look for alternatives. Contact us to see if there's another way that we can shorten that so that you're not waiting 1 or 2 decades just to get permanent residency here in the U.S. Number 4, increased I-9 audits and worksite enforcement. More aggressive enforcement of employment verification increased liability for HR teams as well. Now, we haven't seen this yet because the administration hasn't turned its attention towards it. But this is just the next steps. The federal government is already trying to get the states to cooperate in this immigration enforcement. The next natural step for the government is to force us employers out there to turn in our own employees or to hold the business owners accountable if there are illegal people working for you on site. So this is going to be an exciting area. The labor law and employment law attorneys are already extremely busy. This is just going to compound that. Attorneys will be busy trying to solve these problems for employers and also guide employers and their owners so that they don't run afoul of the immigration law or the policy that's introduced. Next, number 5, wage and labor condition application changes. What changes could we see? Potential increases in the required wages for visa holders, affecting salary structures. We saw this the last time the administration was in power. They attempted to, unsuccessfully, they attempted to increase those wages to numbers that really are astronomical for the average employer out there, unless you're in Silicon Valley working for one of the big tech companies or large corporations. H-1B is not only designed for large corporations. It's designed for large, medium, and even startups and small companies. We need to make sure there's equity in the H-1B system and not 85,000 visas just reserved for big and large companies that already have a sea of employees. Next, number 6, limits on employment-based green cards. We could see administrative actions slowing down green card issuance, which in turn could create talent retention issues. Just as I mentioned before, if someone from India or China has to wait 2, 3, or even 4 decades to get a green card, are they going to continue to stay here, or are they going to go to Canada, where they're invited and welcomed in, or Australia, or the European Union? That is a loss of talent that makes the U.S. less competitive. And let's be honest, $85,000 a year is not taking away U.S. citizen jobs. Obviously, we need to get U.S. citizens retrained for the new technology, electric battery innovations for EVs, and also going to space and AI. All of these technologies are new industries that we need to train U.S. citizens for so that they can get jobs in those areas. Next, tighter requirements for employment authorization documents. These are EADs, or work authorization permits, the processing delays, and policy changes impacting work authorization for foreign employers. We could see delays, we could see higher requirements. Number 8, restrictions on business and investor visas. How about E1s, E2s, L1s, EB5s? We're looking at increased scrutiny on business and investor visas, making it even more harder than it already is for employers to transfer key employees. Let's face it, many people really don't understand employment immigration. It's rarely talked about. But getting work permits for employers is costly and it's challenging. It is not a cakewalk, and the government has never handed these out. Therefore, the U.S. population, the news, really needs to reflect that this is a very small part of our whole U.S. economy, and there's no reason to make it more strict or more difficult for foreign nationals. Number 9, a shift between domestic hiring policies. As you know, Buy American, America First, we might be seeing more Buy American, Hire American initiatives creating challenges for global hiring strategies. Sometimes we can't find U.S. workers willing to work, for example, in Tennessee or Kentucky or Indiana, where these factories are located at. People just don't want to move, or maybe financially they cannot move. Therefore, there are not enough people or individuals to work at these factories in these new jobs in AI and EV in order for them to grow and expand. So we got to keep everything in perspective. We need to make sure that we're looking at everything clearly, not just, hey, I'm sitting in, Chicago and I can't find a job. Sometimes you got to move to get the job that you're seeking. And number 10, potential further executive orders and uncertainty. We see this every day, don't we? Every single day, a new executive order, whether it's directly aimed at immigration or not. For example, tariffs. These executive orders, such as tariffs, conflicts between our various countries, impacts immigration directly. And you, as a U.S. population and employers, will see this on a daily basis. Whether that's your own employees who disappear because they were on TPS from Venezuela, or if there are individuals who, for example, had an H-1B, but due to the changes cannot extend or get their H-1B renewed. Or if they're on a green card process and the government changes the policies. We do not know when the government will make these changes. So we need to be prepared for that. Just checking my chat, see if there's any questions or chats. Again, any questions, put them in the chat below, okay? Now, we talked about a lot of challenges and some of the concerns that HR managers are facing. Now that we have a clear understanding of the challenges others are facing, it's important to shift our attention or focus towards actionable solutions. By identifying key strategies and best practices, we can take proactive steps to minimize the impact of the concerns outlined above, whether it involves implementing new policies, improving communication, or what we're going to talk about today, leveraging available alternative visa resources. Our goal is to create a more effective and sustainable approach to addressing these issues. Let's explore some practical or potential ways to mitigate these challenges and enhance our overall outcomes. First up, E1 and E2 visa applications. Now, how can the current administration impact e-visas? As you know, or may not know, e-visas are based off of a treaty. But if the treaty is withdrawn by the U.S. or changed by the administration, this could undermine all visa E2 and E1 visas, whether you have them now or whether you have them in the past or you're about to get them. So, with the state of our administration using treaties as a tool to get what it would like to achieve, there is a huge risk for employers who rely solely on the E1, E2 visas. You need a backup. Changes in the treaty could impact you. Reduction in the staff at the State Department could impact the processing times for you to get your employee here. Right now, for certain posts, it may take 3 or 4 months to get that employee here. If there's nobody there to process it, now we're pushing that out 2 years, okay? And we need to come up with a better strategy. The government or administration could change the requirements and the enforcement of visas at the port of entries. Unfortunately, remember, when they're denied, there's really no review. You can't appeal to a court, and you're really locked out of the U.S. Refiling the same application expecting a different outcome is what we call immigration insanity. What's our backup? I'm encouraging our clients to have a backup. Don't put all your immigration eggs into one basket, okay? We want to make sure that if the e-visas are taken off the table, we still have a variety of visa categories that we can turn to keep your employee here and to keep them employed. Next, what do we use for a backup? We can utilize the L visa, which we'll talk about next or very soon. The L visa, intercompany transferees. You may need to send the employee back for 1 year, but then they can come back and continue to work. We can look at the H-1B. If you're looking at the H-1B, the H-1B registration or registration lottery is next month in a couple weeks. So reach out to us at 888-401-1016 to get set up and in that H-1B CAP registration lottery. You want to be involved. Now, one that many people don't talk about too often is the O-1 visa. Depending on your employee and their accomplishments, we may also consider the O-1 visa, which is for individuals with extraordinary ability in business and science. It's not a high level like on the green card. We do have everyday ordinary people, more or less, who can qualify for the O-1 visa. Now, depending on the position, we would also consider as our backdrop, as our last resort, maybe a J1 visa or even an H3 visa. Both these visa categories are trainees. The J1 has a trainee category, and it's a good way to sort of bridge the gap if you're not selected, for example, for the H1B lottery this year. Let's move to the next one, H1Bs. Okay, just a reminder, if you have questions even about these specific categories, or maybe you have a question that is even unrelated, go ahead, drop that in the chat. Let us know what you're thinking. Or if there's other topics, maybe next month that you would like us to cover or touch on, we're listening. Put it in the chat and let us know. Next one, H1Bs. For those who are not familiar, H1Bs are for professionals. This includes positions that require a 4-year degree. Think lawyers, accountants, engineers, doctors, and computer science occupations, and many, many more. So in this category, some of the issues that we're going to face, as we mentioned earlier, is they can change the wage. Already, we've talked to many small employers that just can't even pay right now the prevailing wage for their area. It's just too high. It's unrealistic of what the Department of Labor has set for that wage. There are ways to address that, but it's not always fail-safe, and there are time limitations that we have to deal with in the H-1B process. Another one is stricter enforcement. Now, we encourage, we want the USCIS and DHS to have more inspections. Enforce, check employers out, see if they're living up to the regulations. The problem is that there's just not enough people to do the job, as if with many enforcement ideas that this administration would like to do. However, that's a concern. We want to make sure that that's a concern that it could be more strict for H-1Bs. Another concern was that they could try to limit the H-1Bs. Last year we had over 400,000 applicants apply for the H-1B cap registration. This year, they did increase the filing fee from $10 to $215. So while that will discourage a lot of people to file that many cases, we still could see anywhere north of 200,000 to 300,000, as $215 for most corporations is not a real deterrent if they really need these key individuals. Now, for backup for the H-1Bs, you have to plan in advance. These are just a couple. Maybe the L visa if we send the employee abroad for 1 year and they come back in. Many attorneys have talked about how to get foreign nationals into Europe, Canada, Asia, and Mexico to spend a year before they're transferred back to the US. The E-visa category, which we just talked about briefly, for certain individuals and countries that have E1 and E2 treaties, they can utilize this. And never overlook or forget about the O1. So many people utilize that and qualify and get that. It's a good alternative. J1 and H3 alternatives if that doesn't work for you. Don't limit your options just because you think you know of all of them. Let the experts, let us at Ray Law International figure it out. Look at the employment, look at the company, the position, and see what kind of positions this person can really hold in the company. Next, let's look at the L1 petitions. Put that on the screen. L1 petitions, we're going to talk about L1 blankets in a minute, but this is L1 petitions filed here in the US, okay? Some of the things that we could see is even more strict. I mean, it's already strict as it is, but even more stricter requirements and making it more difficult for companies to, get their petitions approved here in the US. Like the H-1B enforcement, probably not so much. The cost has gone up for all employment based because now all employers have to pay an asylum fee, whether that's $300 or $600. There are exceptions for nonprofits. However, you've got to pay a lot more. So the cost of this is even going up to petition for foreign nationals. So if people say, hey, it's cheap to bring foreign nationals here, they haven't looked at the filing fees. Under the H-1Bs or even the Ls, employers are paying just for the filing fees alone, not even talking about attorney's fees, about $2,000 to $4,000 in filing fees to the government alone. Okay, and then you tack on legal fees and other expenses. It's not cheap bringing over a foreign national, whether that's under the L that we're talking about now, H-1Bs, or even the H-2Bs or H-2As, where we have agriculture and non-agricultural positions being filled. Now, what are some alternatives to the L? If you are using the L category and then the government puts up roadblocks and makes it difficult, you should always have your H-1B. H-1Bs can be applied for now, and you can apply for visa processing and put that H-1B in your pocket for whenever you need it. You don't have to use the H-1B right away. There has to be a position and work available, but you don't have to use it. You can sit in L for 1 or 2 or 3 years, and then if the administration limits or makes it difficult, you now have your H-1B available so that you can have that employee to continue to work. It's an investment, but it's a smart business investment for you to have that key employee continue to work with you throughout the process and throughout all of this. As well, e-visas, depending if that country or if the country and the employer meets the requirements for the e-visa. And then the O1. We have many, many, many talented students coming out of the university with experience that will qualify for O1. Just because you hear about outstanding, don't let that scare you, okay? Many people meet the O1 visa requirements, and this is a great way to have as a backup to the L's. Now, let's continue on. I want to try to keep this to about 30 minutes. Next is the blanket L. Let's put that up on the board. So the blanket L petition is very unique. Okay, let me get some water. All right. Blanket L, there are certain requirements employers have to meet in order to have a blanket L. The nice thing about this is they can apply directly at the embassy instead of going to the USCIS and then the embassy. Generally speaking, you may have over 1,000 employees, for example. You may have gross sales of more than 25 or 30 million, or you may have, I believe it's, 10 L's within the past, 1 year to meet those requirements. Most of our clients will meet the requirement based off of gross sales here in the US, which is very common. 25 million for many companies is not that high. Anyway, so once you're approved for the blanket L, the nice thing about this is you can get people over here fast, okay? We're talking 1 or 2 months depending on your post. Probably not Mexico, but many others, you can get people over here very quickly. Under the blanket L, some of the changes that could be implemented, again, because this is based at the U.S. Embassy, a reduction in staff at the State Department, the U.S. embassies, could cause delays, okay, and processing times. In addition, with the L's, they could make the rules a little bit more stricter. For example, L1Bs here at the USCIS are not as are more strict than they are if you apply for your L1B abroad. Now, L1Bs abroad at the U.S. Embassy are for professionals only, but still, the standard is so much more reasonable. I'll say reasonable instead of lax. It's just more reasonable, and it makes good business sense. One of the things we often forget about immigration on the business side is employers are going to do what makes business sense, right? They're not going to hire all these people if there's no business, if there's no work. If there's no money coming in, they're not going to do the visas. So people are in the business of making money, not just spending money on people's salaries to bring people in to sit in the US. It doesn't make any sense. So I think the majority of employers are, doing what they're supposed to. The amount of fraud in H-1Bs and other categories, even though it's, put on our media every day, it's really less than 1%. Okay. And so we really need to focus on what we're all about, what employers want to do. We don't do this just to get visas or spend extra money on other people. Now, what are alternatives? What are some backups for the L's? Like the alternatives we talked about before, we can look at the E visa category, the O, the H-1B. Again, H-1B cap registration coming up. Just do it. It's $215. Plus, if you have an attorney, there may be attorney's fees, but just do it. It's worth the investment, especially in these uncertain immigration times. You don't know what's going to happen tomorrow or even next week. I don't even know because the administration has not made it clear of how and when they're going to proceed. So for the blanket L petitions, there are many options that people can utilize. Of course, there's a lot of factors we're not going to be able to discuss today, such as the position, whether the person is qualified, all of that, but it's a good option. Let's jump to the O visa. The O visa, the way that they could impact the O visa is, and they didn't do this so much last time, it just depends whether the new administration has the time, the bandwidth to even get to all these visa categories, okay? The O one's one of those quiet visa categories that sits tucked neat away, and most people don't even talk about it. However, these are people who are outstanding in their field, whether business, athletics, sports, academic, and we can utilize this visa category in order to get people here to work and to stay here and do what they need to do. Now, they could make it more strict. Yeah, they could. They could tack on more fees to make it more expensive. Some of the backups are ones we talked about previously before: H-1B, Ls, Es, and many others. Okay. Finally, before we talk about a few alternatives, is the TN visas. Now, this is a big one. I know a lot of employers are not taking action that we think they should be. They need to take this administration serious about immigration. They're deporting people whether you're a criminal or not. If you're here illegal, they are going to squeeze everybody, including employers. And if they've got to take away your TN workers and you're heavily relying on TNs, that could be your business. That could be your contract with your supplier or your client. Don't take the risk. Invest. That's why we have insurance. Think of this as your insurance. TN visas are based off of a treaty, just like the E visas. It's already been challenged. It's been, the treaty has been violated or changed already. The administration could utilize that as well, again, and try to take teens away in order to get what they would like. This will impact your business. You need to have a backup. Please have a backup. One of the best backups can be the L visa. Now, I can't advise on the tax side of things. Talk to your accountant, talk to your business attorney. But the L visa is a good option if you have a business abroad. Say you have an office or manufacturing company or business operations in Mexico, and you have your office here in the U.S. You can set up your L visa relationship and meet those requirements and move people back and forth if the TN is taken away. Alternatively, people say, well, I've got the TN, I don't need anything else. You could use the H-1B, as I mentioned before, as an insurance policy. Get the H-1B, do visa counseling process, and put it in your pocket and use it when you need it. Okay? You don't have to use it. Those are valid for 3 years. Okay? You can stick with the TN until you need that H-1B. Additionally, we looked at the O visa, and we looked possibly the E visa as well for certain companies. So look at all your options. Make sure you have a backup. Now we're going to look at a few specific categories that may not fit for all of our listeners out there, but they are available. The first one we're going to look at as we wind up, the R1 visa. The R1 visas are non-immigrant religious worker visas that allow foreign nationals to enter the U.S. temporarily to work in a religious organization or vocation for a recognized nonprofit religious organization. Okay, so I think we had a potential person reach out to us. They had a religious education and everything. They were looking at the H-1B, but they really hadn't considered the R1 visa. The R1 visa is not subject to a cap. So you can go and get your R1 visa anytime, and we've done it multiple times. So look at all your options. The R1 visa for certain religious organizations may qualify. Next one, Q1 visa. You heard that right, a Q1 visa. You're saying, Mr. Ray, is there a Q1 visa out there? What is a Q1 visa? The Q1 visa is our exchange visa category. It is a non-immigrant visa for individuals participating in international cultural exchange programs. It is designed for foreign nationals to come to the U.S. to share their cultural traditions, their culture and traditions through participating in training, employment, and cultural exchange programs. So this is another way to get people here for a short period of time to do that. Now, even once you get it approved here at the USCIS, you still got to make sure that you get it approved at the embassy. Okay, it's not automatic all the time. Sometimes the U.S. Embassy goes way beyond what they're authorized to do, and they re-adjudicate a visa, whether right or wrong. It just doesn't make any sense. So be cautious about the Q1, but that is an option. Next, the J1 category. J1. The J1 visa are non-immigrant visas issued by the U.S. to an individual participating in an approved exchange program that promotes cultural or educational exchange. These programs are often sponsored through educational institutions, businesses, or government agencies. There's a long laundry list of J1 categories. We're not going to talk about them all today, but there is one that we mentioned before, which is the trainee. So look at that. It's a J1 trainee where individuals participate in a structured work-based learning program. So that's very good for employers to look into that. Next, P1, last and final one, P1 visa category. The P1, although it traditionally seems a little bit out of reach, it depends on your industry and what the person's coming to do. I mean, the P1 is for athletes, entertainers, artists, and other essential support personnel to come to the United States for a performance or training or certain events. Okay, and so this could vary whether you're doing a tour throughout the US or whether certain events that people are going to be participating at. So we can help to see whether you qualify for the P1A or the P1B, or if you have support people that also meet under the category as well. So let me see if we have any questions. Let me see if we have any questions in the comments. All right. If there's any other questions, let me know. Thank you guys for joining today. I really appreciate it. I hope that the information we talked about, it's a lot. I hope that it was extremely helpful. Reach out to us to schedule a time for us to talk to you and your employer or your company to find out more information about the various visa categories that can help save your employees and your company as you move forward. You can reach us at 888-401-1016. Until next time, stay informed, stay educated, and stay on the right immigration path. Thanks for watching.